When is the best time to apply for asylum? My friends, the best time to apply for asylum is within 6 months of your arrival in the United States, when your B1/B2 visa is still valid. That is the best time to apply for asylum. But of course, you can still apply for asylum within 1 year of your arrival in the United States. You can even still apply for asylum after 1 year, provided that you meet the 1 year deadline rule exceptions. But in this video, I will explain to you why it is best to apply for asylum within 6 months period of time. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. My friend, we are still trying to get to 1,000 followers on Instagram, TikTok, Facebook page, and Facebook group. Please share my videos with friends and family. It can actually help somebody out, okay? And don't forget, we have a live session in celebration of Mother's Day. We have a live session on Saturday, May 13th, 3 p.m. Eastern time here on YouTube. Join us and let's celebrate. Then we're going to talk about those 7 ways your U.S. citizen child can offer you legal status or protection in the United States. Let's get right into it. Why do you have to apply for asylum within 6 months of your arrival in the United States? If you have a valid claim for asylum and you really want to apply for asylum and you got here with a B1/B2 visa, well, you need to apply for asylum within 6 months, okay? Why? Because later on in the process, because those asylum cases are pending forever with USCIS, later on in the process, let's say someone wants to sponsor you for a green card, an employer, or you want to sponsor yourself, EB1, EB2, based on your own merit, right? You want to sponsor yourself, then at least you will have a room for argument. Remember, there is a case law in the 9th Circuit which actually allow people to adjust status on the employment based on technical reasons, okay? And the argument is this: well, I am still within status because I failed to maintain status due to technical reasons, not fault of my own. It's not my fault. I applied for asylum when my visa was still valid. However, USCIS has not adjudicated my petition yet. So why do I have to actually pay the price for it? Why do I have to go with the consequences of it? So it's USCIS fault, technical reasons. Well, I need to adjust status. So there's a case law in the 9th Circuit that really has helped some individuals over there. Again, you can still use it persuasively in other circuits if you fell into that fact pattern, okay? So that's why we really encourage you, if you have a valid claim for asylum, to actually apply for it within within 6 months, so that you can have other chances later on in the process. But again, if you did not do it within 6 months, you can still do it within 1 year. If you did not do it within 1 year, you can still do it after 1 year, provided that you actually meet the 1 year deadline rule exceptions, okay? Change circumstances that materially affected your ability to apply in time, and or extraordinary circumstances. As far as change of circumstances, well, in the 4th Circuit here in Maryland, we have a case law where that even when the circumstances happen later on in the process, you can still claim it, right? Provided that those circumstances really affected your ability to apply for asylum. And it has to be after those change of circumstances happen. It has to be within a reasonable time that you actually went ahead and apply for asylum. For example, let's say that somebody died in your family. Well, that can be change of circumstances that can fall into extraordinary circumstances as well. However, when you claim change of circumstances, if the person, let's say, died on January 1st, well, you can't wait until December 1st. That will not be reasonable, okay? It has to be within reasonable time. Maybe 30 days is reasonable time, okay? Then you apply for asylum and use that exception, extraordinary ability beyond your control. That can be illness, disability, legal incapacity, death of immediate relative, or then you can also claim ineffective assistance of counsel, okay, and still apply within that 1 year, still meet that 1 year deadline rule exception. So that's what we wanted to tell you about asylum. And really, especially when you're trying to claim that exception under extraordinary circumstances and you're claiming ineffective assistance of counsel, my friend, when you're claiming that, there is a procedure to follow, right? You have to talk to the lawyer first about what went wrong and give them the opportunity to respond or to fix the problem, then file a complaint, then now claim it, okay? If you fail to file a complaint, then you have to explain why you did not file a complaint. So procedurally and substantively, you have to follow those procedures when you are claiming ineffective assistance of counsel, okay? And a good example is this. I have one potential client who actually, when he came to the United States, you know how they ask people at the airport, the officer asked him, because he had a visitor visa, B1/B2 visa. The officer asked the person, like, well, when are you planning to go home? The person didn't know how to answer that question because he was actually on the run, right? He came so that he can apply for asylum. And then he told the officer, I am not going home. I'm here because I want to apply for asylum. Well, then his case was directly transferred to ICE and he had to report to ICE. So what happened in that situation was they gave him some type of rendezvous, some type of appointment to go and report to ICE. Unfortunately, they went there with the lawyer. It was a Sunday, ICE was closed, the office was closed, and then instead of that lawyer really, instead of the lawyer to actually wait until Monday to go again to report to ICE, the lawyers did the mistake, made a mistake, of course, and then filed with USCIS, the asylum petition with USCIS. Well, that's a mistake because at that point, USCIS does not have jurisdiction. The person is already with ICE. USCIS lack jurisdiction, and what happened was the case was dismissed for lack of jurisdiction. So now time has lapsed, right? So the person still has a valid asylum claim, but they cannot file it because 1 year has passed. But again, because of this 1 year deadline rule exception, so they can bring that claim of ineffective assistance of counsel, then pursue again asylum with USCIS, because ICE hasn't done anything with the case. It's just there, right? So the person still has the right to actually apply for asylum. But then still, again, you have to follow proper procedure. When you are really claiming ineffective assistance of counsel, you have to follow those procedures, okay? If you need a consultation with me, you can actually schedule it on your own time by using the link in the description box below. Also, you can email me if you want, bijoux.ngwandaesq@gmail.com. Then I'll send you the link for consultation. Again, if you want to just ask questions randomly, you can post them on YouTube. You can post them on our private Facebook group. You can post them on my Facebook page. You can post them you can comment on any post on Instagram or TikTok. So, and then we'll try our best to answer you, okay? Until next time, bye-bye.